Yes. Have folks been let in?
Yes, I think when I started the webinar, it actually let everyone in at the same time, and I could not figure out how to reverse that.
Great.
So, hello everyone. Um, my name is Haley Miller. I am the past president of the National Disabled Law Students Association. Um, I am here to host this event tonight. With Brown Goldstein and Levy, and I'll actually turn it over to one of the presenters to do more of an introduction. I don't know which of you would prefer to go, either Erin or Neel. Um, yeah, thanks everyone.
Sure. Yeah, thanks so much for having us. So just by way of introduction, so Erin and I work at a law firm, Brown Goldstein Levy, based in Baltimore. And we'll talk a little bit kind of about what we do at the firm. But, among other things, we represent students and professionals who are seeking accommodations in a range of contexts, but including high stakes testing. So, we come to this, presentation from that experience and hoping just to share, a few tips, some legal background, and really to learn and from others' experience and answer questions as we can. So we have a PowerPoint that we can circulate to the organizers, and hopefully they can circulate it to everyone who joins today if that's helpful. But yeah, Erin, I don't know if there's any other introduction you want to give, or if we can throw up the PowerPoint.
Yep, no other introduction. Thank you for doing that, Neel. I can share the PowerPoint unless one of the organizers wants to instead.
This is Marissa. I'd also like to do a really quick
Sure.
introduction. My name is Marissa Ditkowski, pronouns she, her. I am a white woman with dark hair that's pulled back and glasses. I'm the executive director of the National Disabled Legal Professionals Association, the sister org of the National Disabled Law Students Association. We're really excited for this event. And if you have any questions, we'll be able to have those answered at the end. And I just put some links in the chat to all of our websites, and we'll be sure to provide you with our contact information at the end. I would just request for presenters, if you can say your name before you speak, just for access reasons, and if you could just keep yourself a bit conscious of making sure you are speaking clearly and at a good pace for the captioners and interpreters. That would be extremely helpful. Thank you, Erin and Neel. I will send it over to you.
All right.
This is Neil. Thanks, Marissa. And yeah, we'll get the PowerPoint up and get started. All
Can you see it,
right.
Neel?
Perfect. So, just by kind of way of background, we have in our, experience, seen a lot of hostility and backlash to people, to applicants with disabilities who are seeking accommodations. I feel like there's been this wave of testing entities who have decided that applicants are trying to get a leg up. And what's happening, which is a total misconception, of course, and what's happening is they are denying valid accommodations almost kind of, wholesale. So I just wanted to set the stage because, that backlash is kind of what, we're up against. And there's a lot of, misinformed ideas about what accommodations are, what they aren't, and the applicants who are seeking accommodations. So we really come to, this work with that context. And yeah, just to talk a little bit, we can go to the next slide, which is just, the agenda for this evening, and we'll try to go quickly, but leave plenty of time for questions. We're going to talk about the purpose of testing accommodations and some different examples, eligibility for accommodations, and then really dig into the law in this area a little bit, and some practical advice on how to apply for accommodations, some pointers we think that can really help an application stand out. And then if you find yourself in a situation of, an unfortunate situation, which I'm mentioned is all too common, of having your accommodation application denied, how you can go about to try to fight that denial, and some of the best arguments you can make, and some of the steps you can take to really give yourself the best chance to secure accommodations that are needed. So we can turn to the next slide and just, high level purpose of testing accommodations. And this is really key, which is that they are designed so that an individual can demonstrate their true aptitude or achievement on a standardized exam or other high stakes test. So that is always kind of the North Star. That's the standard that we emphasize. And when we write letters, when we kind of pursue appeals, a lot of times you'll get this attitude from testing entities that say, well, if the applicant can, perform at an average level, then they don't need accommodations. But that's a totally incorrect way of thinking about accommodations, because if someone can actually perform at, say, the 90th percentile with accommodations, and that is their true aptitude, then they should be given that chance to do as well as they can on the high stakes test. So that's one misperception that we see over and over again. And this is, again, the standard that we look to. And, we also have a quote up here from a Ninth Circuit case, and I'll just, read it out. It's the Enyart versus National Conference of Bar Examiners. And this is from the Ninth Circuit in 2011. But really the purpose of testing accommodations is to make sure that people with disabilities are not foreclosed from educational, professional, or trade opportunities because of an examination. The reason these accommodations and these tests are so high stakes is because, of course, they represent a gateway into a profession. And after a student or a professional has gone through all the other steps, for them to be denied entry into the legal profession in this case because of an exam, we highlight the injustice of that, and really kind of, I'd say, center that that understanding that this should not be a barrier to entry for the profession, and unfortunately it has become in a lot of cases. And we can move to the next slide, which is just some examples of testing accommodations. And the general principle here is pretty standard, which is that accommodations must be tailored both towards the specific disability and toward the particular setting. So, one example of the particular setting is that while someone might not have required a particular accommodation earlier in their academic career, for something like the bar exam, for example, which is, one of the most intensive exams, over multiple days, switching between different subjects, they might require, a different accommodation than what was required previously. And there's lots of examples, there can be, accommodations. Oh, I think we're just going to hold on 1 second.
My apologies. You can go ahead.
Okay, yeah. So just lots of different examples. Obviously there can be, Braille or large print exam booklets or screen reading technology that's provided, and we've helped students gain access to those accommodations if required. The most common accommodation we see is extended time. And, that can be 50% extended time, 100% extended time. And again, depending on the particular setting, the particular needs of the student, the particular exam at issue. A lot of times we'll see distraction-free environments, or at least reduced distraction environments. So that could be testing in a small group or even an individual setting. Other examples that we provided, permission to bring and take medications, for example. Sometimes, depending on the jurisdiction, you don't actually have to seek accommodations to take medication, but other jurisdictions actually require you to go through the process and make an explicit request. So, It varies from, state to state, and also kind of depending what test we're talking about. But those are just some examples, and this list, it's important to recognize is not exhaustive. It really, again, has to be tailored to the particular person. So with that, I'll pass it to Erin to kind of move forward to the next slide.
Yes, this is Erin taking over for Neel. And I'm going to talk a little bit about eligibility for testing accommodations now that Neel covered what sort of the realm of possible accommodations might be. So the way that the law thinks about eligibility is that under the Americans with Disabilities Act, which is one of the federal laws that will apply here, an individual with a disability is someone who has a physical or mental impairment that substantially limits a major life activity or a major bodily function. So something that we keep in mind when we think about advocating for people in high stakes testing, and something that you should keep in mind as you're applying for accommodations for high stakes tests like the bar exam, is that the ADA is meant to make it easier for people with disabilities to obtain protection. And that quote that I just read comes from a Fourth Circuit case from 2022, Williams v. Kincaid, I think is how you say it. And it basically quotes ADA amendments from 2008 that says the statute was intended to make it easier for people with disabilities to obtain protection. And Congress instructed when passing those amendments that the definition of disability should be construed in favor of broad coverage of individuals to the maximum extent permitted. So Williams was not specifically a high stakes testing case, but what Neel and I have seen as we've done this work is that similar language appears in case law, specifically from district courts, that are looking at high stakes testing and what sort of accommodations should be allowed to students.
And Erin, if I can, add
Please.
one thing. This is Neel again. So the definition that you read about kind of, major bodily function, I just had a case recently where a student came to us and was seeking accommodations based off a diagnosis of ADHD, but in the course of their evaluation with the clinician, the student mentioned, well, I've had, this severe nausea, so severe that I had to take a semester off of, from college. And the clinician said, well, that can also form a basis, for an accommodations request. That you should only be, required to test in the morning because the nausea got worse in the afternoon. So that was another example of kind of fashioning a particular accommodation, and the student, hadn't initially realized that that was a valid basis for seeking a modification to the testing environment and the kind of the testing timeline.
And I think that really speaks to the part of the quote of in favor of broad coverage to the maximum extent possible. So something else that guides our understanding of testing accommodations for particularly high stakes tests is this guidance from the US Department of Justice. So on the slide, you'll see that it was last updated in February of 2020. And this guidance is still posted on ada.gov today. We checked. So essentially what the Department of Justice says is that a bar examination entity must administer its exam so that it accurately reflects an individual's aptitude, achievement level, or the skill that the exam purports to measure, rather than the individual's impairment. So this point is so important that Neel has already made it, and we're going to make it again here, that accommodations on an examination like the bar exam or like the MPRE or like the LSAT are meant to allow the test taker to show their true aptitude. Even if you could pass the bar exam without accommodations, that doesn't mean you aren't entitled to them, and it doesn't mean you shouldn't seek them, because what these accommodations are seeking to do is show your true ability, not how well you can compensate without the accommodations. True aptitude is what we think about, and that phrase is blessed by the Department of Justice. So also from DOJ, something that a high stakes test entity should consider when evaluating a request for accommodations is an applicant's history of prior accommodations. So DOJ gives some examples that things like accommodations on similar standardized exams, or accommodations received during public or private school, or even informal accommodations. Like if someone writes in their application that during high school they were always allowed to finish tests during lunch or after school, that counts as something that testing entities should consider. So for a law student applying to take the bar exam, the type of history that you would want to emphasize in your request for accommodations is any accommodations that you received during law school, accommodations on tests like the MPRE, the LSAT, undergrad, and can go back as far as you have in terms of history. But the board of law examiners in whatever jurisdiction you're taking the bar exam should consider that history when deciding whether to grant accommodations. Something else that testing entities should consider per DOJ is that the entity is required to defer to the evaluation of a qualified practitioner or clinician. So what that essentially means is that an applicant for accommodations on a high stakes test that submits documentation from, say, an evaluating neuropsychologist, for example, or another qualified practitioner that has assessed the applicant and made findings about the accommodations that they need, the testing entities should defer to those rather than making their own assumptions or their own evaluation based on paper and not based on an actual evaluation of the applicant. So here you'll see that we've cited another case, Ramsey v. National Board of Medical Examiners, which is from the Third Circuit in 2020, that essentially says that DOJ understands that reports from experts who have personal familiarity with the candidate, so someone who has spoken with the candidate, who has evaluated them, should take precedence over those from reviewers for testing agencies, so the people that are evaluating requests for accommodations, because those people have never met the applicant. They've never conducted an assessment, and all that they have is the papers to go off of. So you'll see that the first bullet point says pretty strongly, a testing entity should generally accept such documentation from an evaluating clinician and provide the recommended testing accommodation from that clinician without further inquiry. Switching topics a little bit, we're going to talk about accommodations on the MPRE. The reason we want to highlight specifically the MPRE is because requesting and receiving accommodations on this exam can lay the groundwork for bar exam accommodations. So a few slides ago, I talked about how your history of accommodations is important to any application per the Department of Justice. Applying for and receiving accommodations on the MPRE can be a helpful step to bar exam accommodations. So looking at the MPRE's specific requirements, something you'll notice in a few slides is that every jurisdiction is different in terms of the timeline during which you'll apply for accommodations. On the MPRE specifically, it's recommended that you submit your request for accommodations 2 months before the deadline to register for the exam itself. If you apply later, you might still get your accommodations, but it's possible that you have to take a later test because the testing entity just didn't have enough time to evaluate your request. So throughout this presentation, a recurring theme is make sure you know the deadline, make sure you know when to apply, and make sure you give the testing entity enough time to evaluate your request to make sure that they've got enough time to give you the accommodations that you need. One nice thing about the MPRE in particular is that if you're approved for accommodations, you're approved for a quote unquote period of eligibility, which means that if you take the MPRE again, you won't have to reapply for the same accommodations. During that period of eligibility, any MPRE that you register for, those accommodations count. You don't have to re-ask. One more before I turn it back over to Neel is that the MPRE website has a very handy section on medical documentation guidelines. So a few slides ago, when I talked about, the evaluating clinician and how a testing entity is required to defer to that person's findings and the accommodations that that person says that you need, the MPRE provides guidelines for what that documentation should look like. So for example, it should be printed on an official letterhead or typed. It should look official in some way coming from someone who's evaluated you. And for example, it should state any diagnoses. It should describe the specific functional limitations that you're claiming and explain how the disability that you're requesting accommodations for will impact you in taking the test. And essentially, we think that this list from the MPRE is a really helpful resource to take into bar exam accommodations as well, to think about what kind of documentation you need from the person who might have evaluated you in order to show the testing entity exactly what accommodations you need and why you need them. Something else to know is that this list comes from the MPRE's general guidelines for medical documentation. But the MPRE website also has helpful resources for specific types of documentation for disabilities like ADHD, visual disabilities, and other categories. So it's a resource that's worth looking at as you're thinking about gathering your materials for MPRE accommodations requests and bar exams accommodation requests as well.
Mhm. Yeah, and Erin, just on kind of that point, this is Neel again. There was a question in the chat about, how can you best prepare the evaluators if they're not used to, providing these official reports? And the best answer is to give them this checklist. Send this to the doctors, to the clinicians in advance. And usually, clinicians are willing to work, with the individual, and once they have a draft of the report and say, you just want to make sure that all of these kind of buckets are hit. So, one easy example that we see a lot is a clinician might say, I recommend stop the clock breaks, or I recommend extended time, but they don't go the step further and say why that specific recommendation. I recommend extended time to mitigate the functional limitation of, reading disfluency or low processing speed, whatever the rationale is. If the clinician can link up the accommodation that's recommended with the rationale, that makes it so much stronger, and that's a relatively easy fix. So it might just be a case where you just have to kind of point the clinician, and there's some who do this more regularly and they're familiar, but it really cannot hurt to provide this checklist even to someone who's very experienced. And there's a few other questions in the chat, and we're going to try to address them as we go as best we can. But I'll hit kind of one more that's relevant to this topic, which is how recent does the documentation need to be? And you're exactly right. This questioner says, it's quite expensive, and we recognize it's onerous, it's a burden. And there are certain guidelines. Sometimes it's a 3-year or 5-year. It depends on the jurisdiction. One of the points that we like to make for when it's too cost prohibitive to get a new evaluation, we can say, this is a lifelong disability, nothing has changed. And you try to make that argument so that, if you can't, generate another recent evaluation, that really shouldn't be a bar, and really leaning on some of the principles that Erin described. Say you got accommodations for the SAT, that alone under the DOJ guidance should be sufficient, so long as the disabilities have remained, the same and have the same impact on your life. But if there is a guideline and you're able to get a new evaluation, the most common time frame I've seen is kind of within 3 or 5 years. We can move to the next slide, which is, again, about just the variance, from state to state or jurisdiction to jurisdiction. this is a slide just talking about the deadline for the bar exam, for when you need to seek accommodations. And, it just is different. In New York, for example, it's about 4 months before the exam. And one thing to keep in mind is sometimes states require a separate accommodations application, separate from the kind of general application to apply for the bar. Others, it's at the same exact time, like in DC, which is, you typically March 1st for the July bar exam or November 10th or thereabouts for the February bar exam. And we've just provided some examples from New York, California, DC, Illinois, just to show the variance. But, look up that rule and provide, if you're able to submit as early as possible. The reason it's important is if your accommodations are denied either in full or in part, you have time to therefore, go through the process of an appeal or reconsideration, which we're going to talk about. And I saw, a different question about that difference, which we'll get to. So let's move to the next slide. And this slide is entitled Documentation. And we've provided a regulation at 28 CFR 36.309, which says the request for documentation should be reasonable and limited to the need for the modification, accommodation, or auxiliary aid or service requested. That is the underlying principle, but in practice, what we recommend to our clients is, if you have more documentation, I wouldn't hold it back. And you can also think creatively about what type of documentation you have, or you can even have created, So for example, you're going to have the reports, you're going to certainly have, if you had accommodations in the past, but say, for example, you had those informal accommodations that Erin was describing. If there's a high school teacher who's willing to write a letter describing those informal accommodations, that can't hurt. That can only help, if there's a letter from a family member or a friend, that can describe how your disability impacts you, not only in an academic setting, but in your everyday life. I would include that. And there's no silver bullet there. You don't have to feel like you have to get, necessarily a letter from a family member or friend. These are just some examples. And one of the most powerful pieces of evidence is a personal statement from the applicant themselves, describing, their history with accommodations. And I see some questions in the chat about, and this is common, we see this all the time with our clients. If you have a late diagnosis of ADHD, for example, you can use the personal statement to provide some context, because testing entities will often deny you if they says, oh, you didn't have, ADHD when you were a child, so therefore you can't have ADHD, which is, just really flawed logic, of course. But if you say, there was a stigma within my family, or we moved around a lot, I was never evaluated, you can provide that additional context to explain maybe why, there wasn't an early diagnosis. Or, I had a teacher who recommended, that I be tested, but my parents, didn't want me to be tested. I mean, there's all sorts of examples that we've seen. And the personal statement is really an opportunity to provide that additional explanation and context, as well as just to describe the functional limitations, which is to say how your disability impacts you every day. And I really recommend that students talk about, outside of testing, how your disability impacts you. If you have dyslexia, how does it impact you reading the newspaper when you go out to a restaurant and read the menu? Because that will provide more insight, and we've seen kind of better results when you provide that fuller picture. So that's documentation. We're going to move along to the next slide, which is the common reasons for denial. And it's like all of these testing entities, not just the bar exam, but we see it across the board. They use these same reasons over and over again, even if they're legally insufficient. And unfortunately, it takes a lot of times, pushing back for them to provide the accommodations they should have provided in the first place. And we totally recognize how frustrating, and expensive, taking on that fight can be. But the common reasons we see are, the test takers lack appropriate documentation to substantiate their disability, so didn't have kind of the right evaluation reports. They say the test takers' disabilities are not severe enough to warrant accommodations. And that's where, they often cherry pick, certain statistics and say, well, you got this average score, so you can't be disabled. Number 3 is what we were just talking about, faulting applicants for not having undergone testing earlier in life. So we talked about one way you can kind of counteract that reason. Faulting students for not applying for testing accommodations on prior standardized exams. This one, drives me up the wall because, just because someone didn't seek accommodations previously when they might have needed them doesn't, logically mean that they don't require accommodations now. And the last one, which we've touched on, is oftentimes the testing entity will say, well, you scored well on the ACT, so therefore you don't need accommodations on the bar exam. And again, there's a gap because just because you scored well doesn't mean you actually met your true aptitude. And it also, the ACT is not comparable to the bar exam. So there's, a couple ways to push back on that rationale. And really what we see is that testing entities will selectively look at the reports that clinicians put together, and they'll point to, 1 or 2 test scores. So there are oftentimes lots of other scores that you can use in the report, and to just make the general point that certain evaluation metrics just is not the full picture for assessing someone with a disability. It has to be a holistic review based off of, someone's history, their behavioral interview, family and third-party information. It can't just be judged based off a few test scores. We're going to move to the next slide, and this is the question that we had in the chat about appeals versus reconsiderations. A lot of times what we've seen is the main distinction is that an appeal is you are sticking with the information, the documentation you've already provided, and you're just contesting the reasons that were given for the denial. While a reconsideration is you're including new materials to be considered as part of your request to overturn the decision. So when we represent clients, we try to pursue the reconsideration route if at all possible. You can get new documentation, even if it's from a clinician, it's a 1-page letter saying, here's why the denial reasoning is wrong. You can update your personal statement. You can go get these supplemental letters that you might not have had at the time of the application. I've found that if you frame it as a reconsideration, I think it gives you a little bit of a better chance, because then the testing entity can at least try to save face and say, oh, here's some new information that was provided. So I'm not admitting that I was wrong, the first time, but in light of this new information, we'll grant the accommodations. That's just been our strategy. And again, you can be creative in coming up with the documentation. And it's important to keep in mind that you can't request additional accommodations once you've been denied. So one question that we see a lot from clients is, well, I've received double time in the past, or 200% extended time, but I think they won't, the testing entity, the bar, for example, won't grant me more than 50%. So should I only apply for 50% as a strategy? And we really push back on that. If you have a history, if you have a clinician who's recommended 100%, don't kind of sell yourself short. Ask for the full 100%. And sometimes these testing entities will come back and say they'll give you 50%, but it's better to ask for the full 100% because you might get 100%. And if it's justified by the evaluation, don't kind of, shortchange yourself just because you think you'll have a better chance. I think it's actually better to make the full request initially. And we'll go to the next slide, just in the interest of time, which is timing considerations. This is what we were talking about earlier of applying early as you can, submitting as much as you can initially, sometimes following up with the testing entities if you haven't heard back so that you can get a decision in time. We've actually seen some pretty pernicious behavior. And actually, the last question is, have you seen appeal decisions are delayed until the last possible minute? I've certainly seen decisions on the initial applications even been delayed so that it really jams applicants up. I think DC in recent years has, even if you applied early, they were kind of batching their denials and then they released them all at once. So, one way to try to push back against that is, being proactive, asking if you do have representation, having your lawyer reach out to try to get that decision, at least create a record that, I need to have this decision in time so that you can prepare adequately. Because I know how difficult it is for students when you don't know if you're going to be given the extended time or not. All right, and the last slide for me before I pass it to Erin is, just some general considerations, steps to take if you're preparing your own appeal or reconsideration. The DOJ guidance is great, and once we circulate these slides, there are a few of the cases that we've cited that have a lot of the principles. Consider updating your personal statement, gathering additional evidence. I like to have clinicians, give a point-by-point refutation of whatever rationale was used in the denial. And sometimes some jurisdictions, don't provide any rationale, in which case I would use that to your advantage and say, look, there was no reasoning given. Or if there is reasoning given, then you have a basis to attack and address the specific points. And a lot of times they'll just be, basic errors that we've seen. So that gives you a lot of grounds to point out those errors. And, if you're able to obtain the assistance of a lawyer, unfortunately, these testing entities, I think, take these requests more seriously when they're coming from a lawyer. One thing that we do is, we do the full representation where we, help students appeal or seek reconsideration. But even if that is not an option, you can kind of consult with us just for an hour and we can brainstorm, come up with strategies. Or we've also worked with students and professionals who are themselves preparing the appeals or reconsiderations. And we provide, just guidance or edits as opposed to being the ones who draft as a kind of a middle ground approach. So those are a couple of options if you are able to obtain the assistance of counsel.
Okay, this is Erin again. So something that Neel mentioned, especially when talking about reconsideration, if you are facing an accommodations denial on specifically the bar exam, is supplemental evidence and what you might want to include in order to have the testing entity reconsider the accommodations denial. So here's what we recommend and here's what we think about as we, look at these denials. One important resource is the DOJ guidance. So the guidance is exactly as it sounds, guidance. It's not black letter law. I saw someone in the chat ask a question about, if you haven't had accommodations before, does that preclude you? And I'm not aware of any black letter law precluding you, but the DOJ guidance does say that testing entities should defer to those historical accommodations. So having that in your back pocket and being able to cite that guidance and show the testing entity what the Department of Justice has said they should be thinking about and what they should be considering is powerful. Neel mentioned supplemental clinician letters. So a letter from your evaluator saying, here is exactly why the denial was wrong. Here's why it misinterpreted my original findings. Anything your clinician is willing to say that sort of attacks the denial, which a lot of times, as Neel said, sort of nitpicks little pieces of the initial evaluation rather than looking at the whole picture, can be really useful. Family and friend statements can be powerful as well. Neel touched on this a little bit, but if you have someone in your life that's willing to write about how the accommodations that you need might help in your everyday life, or how the disability for which you're seeking accommodations affects your everyday life, or affects you at school, or affects you on tests, It's just one more piece of the puzzle that can show a testing entity why you need the accommodations that you're asking for on this test. And I think something to keep in mind in this slide, because we're talking about a lot of the same information that we've mentioned before, is that, like Neel said, there isn't one silver bullet. There's not one piece of evidence that's going to be a slam dunk. I'm guaranteed here. So what we're really trying to emphasize in this whole presentation, and on this slide in particular, is the types of things that you might gather to show the full picture of who you are, what your history is, even if your history is that you've never received accommodations before and this is the first time you're ever requesting them, so that the testing entity really understands the necessity of the accommodations for you to show your true aptitude. And that's exactly the type of thing that you could write about in an updated personal statement, talking more about, your own history, whether it's a long history of accommodations or a recent chronic illness that is causing you to have to request accommodations when you haven't done so before. That's the type of thing that goes in a personal statement or an updated personal statement. And then, of course, transcripts, especially if you have transcripts that show this is how I performed academically before accommodations and this is how I performed academically after. That's powerful. Any proof of accommodations that you have, that's the type of thing that will only help in an appeal or request for a reconsideration.
Mhm. And Erin, just to address Marissa's helpful question about the difference again between appeals and reconsiderations, which is the two most common categories. So this supplemental evidence that Erin's describing, that is when you add new evidence not originally submitted and you're seeking reconsideration. That's when you're adding an evidence into the record. But the appeal is where the record is kind of maintaining, staying the same. You're not adding anything new. That's the most common distinction I've seen. It can vary, so make sure to check where you are. But when you're gathering new information and you're providing kind of a new documentation, that's more in the lane of reconsideration rather than appeal.
And here we'll talk about the specific sort of recurring reasons for denial that we've seen and how you can respond to that and how you can respond to that strongly to make the case for accommodations if you find yourself facing a denial. So the first sort of error, the flaw that we see all the time in denial letters is a failure to defer to past accommodations. So if you have past accommodations, that's something that should go in your response to the denial letter. Highlight the ones you've previously received, highlight the first time you ever got accommodations, and then every time since then, and then consider submitting additional documentation. So if you have, I think Neel mentioned this before, if you have proof that you got accommodations on the LSAT, that's important, the SAT, the ACT, even accommodations dating back to, your K-12 education is useful to show your history of past accommodations and why you still need them. Another big reason, another big flaw, rather, that we see in denial letters is over-reliance on the lack of prior accommodations. So what Neel and I have both seen on multiple occasions is a testing entity like the New York bar saying, well, you didn't have accommodations in college and you graduated college, so I don't see why you would need them now. And how you can refute that argument in particular is first by providing context for not seeking accommodations earlier. That's something that can go in an updated personal statement or ideally in a personal statement in the first instance. So talking about your own personal history. Neel mentioned this a little bit, but for example, I was diagnosed with ADHD for the first time in college. I didn't have accommodations in high school, even though I probably could have really used them. And here's how my life changed once I did get them. Even if it's, a diagnosis that is extremely recent for you, sharing that history and giving context can help refute the argument that a lack of history of accommodations is a reason for denying accommodations on the bar. Something else we see is you'll see the third bullet point says disregard of clinical findings. So we've talked a bit about how a denial letter might over rely on certain metrics or certain language in an evaluation. And something you can do is first and foremost, highlight that your evaluator saw you personally and knows you personally. So not only might they have performed testing and other sort of quantitative evaluations, but they also spoke to you in a way that the evaluators who are looking at your application for accommodations for the bar exam simply did not. They don't know you, they only know you on paper. Highlight the relationship that you had with the person who evaluated you, actually in person or over Zoom or however it went. And then highlight the inconsistencies. So if the denial letter, focused on one metric, try to provide the whole picture. Here's why performing really well on one test that an evaluator performed does not mean that I don't need accommodations. That goes back to the true aptitude. Many law students, many people who are applying for the bar exam might be able to pass the bar exam and might be able to perform very well academically with no accommodations at all, but that doesn't mean that not having accommodations allows you to show your true aptitude. Something really important to keep in mind.
And Erin, you made me think of kind of one other example, and this is Neel, which is, a lot of times I've seen testing entities say, well, this student had a good GPA in college, so therefore they don't need accommodations for the bar. And what I've heard from clients is, well, in college, I took a lot of paper-based classes where I had unlimited time to, prepare papers, and that was to my strength. And that's totally different than obviously a timed exam. So that's another example, another, kind of argument that can be made if that's true in your situation.
And that goes really nicely to the next point, which is that the phrase that we use is an outcomes only approach is never proper. That is a violation of the ADA to focus on something like a good GPA or previous academic performance that was average or above average with no accommodations has no bearing on whether you need accommodations now or even whether you needed accommodations then. So pointing out any aspect of the denial letter that focuses on outcomes instead of your true aptitude is going to be a way to show the testing entity why their decision violates federal disability law. So some sound bites that we have on the slide are first from the DOJ guidance that we keep harping on, that a history of academic success does not mean that a person does not have a disability that requires testing accommodations. And a case that is unreported from the Southern District of New York from 2001, but comes from now Justice Sotomayor, is that an individual's disability cannot be based on quantitative outcomes alone. So in other words, like Neel said, scoring well on a previous standardized test, doing well in college, or performing well academically in any setting has no bearing on whether or not you need accommodations now, and you can say as much in a response to a denial letter. And even if your results appear average, this comes from the same case from then Judge Sotomayor, average scores tell nothing about the processes an individual uses and the difficulties that individual experiences in achieving those results. So in other words, how well you're able to compensate should have no bearing on whether or not you deserve accommodations and whether the testing entity should grant them to you.
This is Marissa.
Yeah,
Just a
please.
quick note. We're receiving a lot of questions
Yes.
about what is required for, documentation. And I will say, just as a quick disclaimer, that there are 50 states and each of them has their own requirements. And so while it's a little bit more centralized for the MPRE, for the bar exams, it's a little bit more difficult to say. So you'll want to consult your state bar's rules. Sorry about that. Just wanted to note it because we're receiving a lot of similar questions.
No, this is Erin again. That is a very important and good point. And just like every jurisdiction, as Neel talked about, has different timelines, jurisdictions have different requirements as well, unfortunately. Okay, I'm going to quickly talk about the law firm where Neel and I work before we turn it over to the presenters that are going to talk about their personal experience. But our law firm, as Neel mentioned at the beginning of the presentation, is called Brown Goldstein Levy, and we have a pretty robust disability rights practice. So in addition to representing and helping applicants for accommodations on high stakes tests secure those accommodations, we also work with people with disabilities in all types of other cases like access to technology, voting rights, access to education is a type of case that I personally really enjoy working on are higher education cases, access to things like employment, housing and public accommodation, and really any type of case where someone can bring a claim under the Americans with Disabilities Act and other federal and state laws like the Rehabilitation Act or the Individuals with Disabilities Education Act. The last thing on that point is, in addition to our advocacy and our litigation, we have a consulting arm called Inclusivity that works with entities to help ensure that they're providing accessible technology and works with institutes of higher education to make sure that, before litigation becomes necessary, ideally entities would be complying in the first place and ensuring that they're providing a universally accessible experience and not ever having to hear from a lawyer about it. So something that we try to do is proactive as well as reactive. And I'm going to turn it over now to the other presenters.
Hello, everyone. My name is Anna Elliott. I'm a 2L student in Minnesota at Mitchell Hamlin School of Law. I recently founded the Disabled Law Students Association at my school. I'm the president, and we've just been getting started. And I have a goal with this org to really spread information about accommodations. So I'm so grateful for Erin and Neel to host this event. It's been so much great information that I'm really excited to share with my peers and classmates. A little bit about me, I'll just kind of read off the slide. I started at Fordham University out in New York City, and I transferred during COVID to the University of Minnesota. I was on the rowing team at both of these schools. I've had a love of sports my whole life. I was on the swim team in high school. And currently, actually last weekend, I did a triathlon and I did a few over the summer. It was really fun. Also, over the summer, I applied for MPRE accommodations. I have a visual disability. I have a genetic retinal disease called retinitis pigmentosa. It makes me very sensitive to light currently, and I'm slowly losing vision over time. So I do have a degenerative disorder. I am really worried because I did not get my full accommodations for the MPRE, that this will affect my bar exam testing process in a few years. I requested a time and a half and a break, and I did not get the break. I got a time and a quarter. So I was pretty disappointed about that. The break is really important for my vision and how I proceed through the rest of the test. So I'm excited to move forward with the reconsideration process, but initially it was very disappointing to get that news. I will say I almost went forward with the August MPRE with the accommodations that weren't the right fit for me, but I'm very glad I stuck it out. I'll just have to come back to studying for the MPRE maybe next summer or spring, but yeah, that has been my experience. And I realized through my student organization, I'm not alone. There's many students where this is the same situation. So I'm very excited to spread the word and let everybody know. Oh, and at Indulsa, sorry, I forgot to mention this. I'm the director of community building. So my job is to get disabled law students connected and get the Dulsas across states connected with each other. So I'll drop my email in the chat if you have any questions about reaching out to other law schools in your area and kind of spreading more information about accommodations and anything anything involving community, please let me know. But thanks so much again, Erin and Neel. This was a great presentation. And now Tenesha.
Good evening, everyone. Thank you so much, Erin and Neel and Indulpa for hosting this event and Indulsa. I actually serve with Indulsa as a director of advocacy. And just a little bit about myself, I'm a recent graduate from Mitchell Hamlin School of Law, originally from New York City, and currently living in New Jersey. Oh, I'm an African American Caribbean. Female, and I go by the pronouns she, her. Excuse me for not saying that sooner. Nevertheless, and I recently, over the summer, I was studying for the bar. So my experience, I don't even remember what I do for fun because my whole life for the last 4 years has been trying to get into law school, getting into law school, and then trying to graduate and then take the bar. And during that whole process, I never imagined that I would need accommodations because I never had them until it took me so many times taking that LSAT. And then I spoke with a few people, professionals, therapists and such, who kind of did a little analysis just by nature of what I do as a healthcare professional and occupational therapist. And they told me that my processing was different. It was different. I'm not a 20-year-old woman. I've lived, and I also was a caregiver at the time, running a business and trying to get into law school during COVID. It was just a lot. And so when I start to think about that, I'm like, well, what do I do with that information? And I didn't have to think for long. They told me you apply for accommodations. You need more time to process this. And so started that process. And immediately, and I don't know if it was New Jersey where I am or what, but I applied and they gave me time and a half. So that I thought was so generous. And with that, with the accommodation, I was able to do well enough on the LSAT to be granted a seat at Mitchell Hamlin School of Law. And then immediately with that, I said, well, I'm not going to fail. I can't fail. Failure was not an option. So I said, I have to use this to get whatever accommodations that I can be afforded with that information since it was new. And I was given the same time in all my classes. It wasn't always so easy to navigate, and sometimes it was frustrating. I remember somebody gave me the wrong test. Somebody who needs accommodations, you give them the wrong test, and that just sent me into a whole nother world. But luckily, they fixed it. Mitchell Hamlin is an amazing school. And so then we go to the MPRE and I applied for accommodations and they didn't give me time and a half, but I was happy with the time that they gave me. I think it was an hour they gave me, an hour extra. For me, it was enough, but I still have to take the MPRE again, even though I've taken the bar because I don't need it in New Jersey, but I want it for a neighboring jurisdiction. So I'm taking it again and I'm still using the same accommodation. Now, the bar was another beast because I feel like with all the information that I had, all the previous accommodations that were used, that they gave me, I think it was an hour, it was it wasn't time and a half. They gave me additional time, no breaks. But it didn't seem like it was a lot. And so I applied for reconsideration. And although, because they said they tell you exactly why they didn't give you what you requested. And I submitted more information, even though I knew I submitted the information that they had initially asked for. They said that I didn't have any accommodations before. And I'm like, I absolutely sent them the information. Like I knew that I sent it. So I sent it again and they sent the same information back saying that they were not going to give me additional time. And at that point, I was getting too close to the bar and I really needed to just focus and try to gain some momentum and speed with the whole process because it was starting to give me some anxiety and I didn't want the anxiety to overtake what was going on. But I think if I had worked it differently, I probably could have gotten more information. And I also believe that they wanted that advanced testing, which was cost prohibitive for me at that point. And when I looked into it, it wasn't just the cost, it was the time factor. It was going to take a lot of time because there were wait lists all over the place for this extensive testing that they wanted. So I think being proactive, if you know you need time, you need to start as soon as possible to find out in the jurisdiction that you're going to test in for any of them, that you give yourself enough time to get as much information as you can. And you know, the information can't be refuted if you have it and it's right. I think you just need the time. So that's my story. That's what's helped me get to where I am. And I'm hoping I did everything I needed to do and the bar results come back positive in my favor with the accommodations that I use so that I can continue to help others and advocate in that realm. So thank you so much for listening. And thank you again, Erin and Neel, for allowing us to be present and a part of this.
This is Marissa. Thanks all. Sorry, Neel, did you have something to add?
Oh, I was just going to say thank you back. And actually hearing both of those, stories made me think of, one other point, which is, when these entities come back and they provide you with only a portion of what you've requested, we kind of push back, so I think Anna, you might have mentioned instead of time and a half, they gave time and a quarter. And to us, what that signals is, well, they've recognized that, you require accommodations, but then they've just second guessed, the amount of accommodations. So you almost use that against them if you can, because they've already kind of recognized the need. And there's really no rationale for them slicing in half. But then, also kind of this point about the MPRE versus the bar, once you get to the bar, which is, a lot more complex than the MPRE, even if you only needed time and a quarter on the MPRE, should be entitled to time and a half on the bar just because of how different that exam is. So I think there's still kind of room to work with and some arguments to kind of make in that scenario.
This is Marissa. We have a bunch of questions. I'm gonna try to go through some of these, but one of them was if there is a list of what is considered a qualified practitioner and what credentials are required to make somebody qualified.
This is Neel. Again, with the caveat that it depends, state by state, I think I would start with the documentation guidelines that Erin had pointed to, because there might be some specific recommendations or qualifications that are required. But a lot of times, I would also ask if you are undergoing a new evaluation, you should feel free to ask, is this something you have, done before in the context of a bar exam or not? Because I think just the familiarity with this process just helps. But, a lot of times we'll see, neuropsychologists are fairly common if it, for a certain category of disabilities. And I I don't know the exact. I think some have doctorates and some don't, if I know correctly, but it's not necessarily the specific title, I think. And even I should say, even if it's we have therapists who write supporting letters. So even if it's someone you have an ongoing relationship with, who's not just evaluating for an exam, you know, that insight is really valuable because that could be someone who's known you for years and years. So um, yeah, I don't know if Erin, you have anything else to add on that.
No, I think that that covers it. I mean, my thought was that I'm not aware of one definition of qualified, given the breadth of professionals that might evaluate someone and speak to what accommodations they need. But I think Neil's advice is good. Look to the MPRE list of documentation for guidance that there might be some helpful things there.
This is Marissa, and that might include a clinician or psychiatrist, correct?
Yes, this is Neel. I think that's absolutely right.
Okay. Couple of other questions. One person asks if you've seen that appeal decisions are delayed until the last minute. They just want to know if it's a pattern because it happened to them.
This is Neel. Yeah, I think we touched on, at least I've seen the initial decisions and the appeal decisions. Yeah, really kind of running up to the last minute. And, one of the things that's so frustrating about this process is it's so, one-sided. Like the testing entities, have a lot of the power, and it's so hard to hold these testing entities accountable in court because it's so expensive to bring, federal lawsuits. So I think the best you can do is, reach out if there are others that you know of in your school, in your community, maybe through, these wonderful organizations, and kind of make a collective push if you see that pattern, because I do think that does happen in some jurisdictions. But um, sometimes the squeaky wheel gets the grease. I would call um, and, be careful because places like New York, there's a designated line that you have to call or reach out to. Um, but I would certainly advocate for yourself as much as possible to try to get an answer of so that you can move forward, accordingly.
This is Marissa, and can those processing times themselves be an ADA violation?
This is Neel. That's a good question. I think that could be a new theory, which is maybe something we should look into. I don't know of anything off the top of my head, but there's another question about you know some other cases in this area, and I'm familiar at least a little bit with this TW versus New York Board of Law Examiners case, which is this awful decision out of the Second Circuit, which basically held that the New York Board of Law Examiners was an arm of the state and entitled to sovereign immunity. Um, but it speaks to just kind of there is a need, which we recognize for more systemic change and collective advocacy. So that's something that I know some of my colleagues and I would like to brainstorm of how to bring wider challenges, because in the past, past administrations, I've at least seen particular U.S. attorneys' offices with civil rights divisions have actually, some had made this a focus. That's not happening right now, obviously, but I would like to brainstorm and be part of this, group of thinking about how can we bring broader challenges, and even if it's just, some media public pressure of, you know, testing entities who are holding on to applications or who are denying people who have received them all throughout their life. I think those are powerful stories and maybe at least a starting point for some broader changes.
This is Marissa. I can also say on the TW um, and I know NDOLPA has been working on some potential policy language starting in New York as just kind of a test to see whether we can address these issues through legislation. the big barrier really is the sovereign immunity piece, which basically just means, when a state has sovereign immunity, it means they haven't um, uh, waived their sovereign immunity, right? You can't sue them because um, they have not waived um, their sovereign immunity. So, um, that's kind of the big thing that we don't think will be successful when it comes to like having New York waive its sovereign immunity so that they can be sued for this. But there are other potential options like addressing things through human rights laws, and making sure it's clear that those are specific forms of discrimination, covered under state human rights laws. We can get things passed related to transparency, those types of things. And I know there was also a question about FOIL requests. And one of the things that we are also working on in New York is a FOIL request, to try to get more information about, what is the data, right? What are the denials looking like? What does that disaggregated data look like? What are the qualifications of the folks who are making these decisions? How are they selected? All of those types of things. So if you're interested in that work, please feel free to reach out. We're always looking for volunteers to help. Okay, this is Marissa. So I see in the chat, I was told by Bully you can't foil them. So yes, but also if a lawsuit is brought at some point, then discovery is a whole separate beast. And we figured we might as well try, and see what happens.
Marissa, this is Erin. If you don't mind me jumping into this point to go back to the reconsideration part, as I read the question about, is this something you can foil? What immediately came to mind was, for an individual who did not receive their full accommodations or was denied their accommodations, to me, I don't care if the person who reviewed your application is the most qualified person in the world, the foremost expert in the world on your disability. They did not evaluate you. So you can still point that out without knowing their qualifications. They haven't met you, they haven't evaluated you. Under the Department of Justice guidance, they have to defer to your evaluating clinician. So don't forget that piece too, which is a tiny part of the broader, category of topics we're talking about here.
Yeah, this is Marissa. And like I said, even if you can't go through a FOIL process specifically, these are still things that you can get in discovery. So, okay, I see somebody has their hand raised. Was that an accident? Maybe not. Maybe it was, because I don't see their hand raised anymore. Okay. Okay. So I'm seeing some other questions. How should an individual with newly diagnosed chronic illnesses and no prior history of receiving accommodations go about asking for them?
This is Erin. How I would think about this, my advice in this particular situation would be to remember what we said, that the DOJ guidance is not black letter law. Even though the testing entity is required to defer to a history of past accommodations, if that history doesn't exist, that doesn't mean accommodations are not necessary, and it doesn't mean that you shouldn't be granted them. So the way I would think about going about the process is making sure the testing entity understands your own personal timeline and how your newly diagnosed chronic illness affects your life. So one powerful way to do that is a strong personal statement. Making sure your personal statement is clear that yes, this accommodations request is new. You aren't hiding the ball on that. You aren't trying to be vague about it, but it's new because this is a newly diagnosed condition and it's something that has arisen in your life that requires accommodations now that didn't used to. Talk about how it affects your life and how it affects things like Neel mentioned, reading a menu is a good example. If you have difficulty reading a menu, you would probably have difficulty reading the bar exam. That's a good sort of my chronic illness affects my life in this way, and that might lead to this kind of difficulty on a high stakes exam like the bar. And then whatever medical documentation you have is important to leave nothing out. Anything you have letters from family and friends that talk about the condition, talk about how it's affecting you now. Any medical documentation you have that substantiates what you're talking about, that's the type of thing that you want to put forth. But, Neel said, don't sell yourself short. Don't think, well, they've got enough. They probably don't need to hear this one other thing. Or I should only ask for this many accommodations. I should only ask for 50% extended time because this is a new condition. Don't do that. Ask for what you need, submit what you have, advocate for yourself, because just because something is new doesn't mean that you don't deserve the accommodations that you're seeking.
This is Marissa, and personal statements can go a long way. So definitely make sure to add that and, yeah. Any other thoughts on that? Okay. Couple of other questions. Okay. Where did it go? Okay. So someone wanted to know if a lot of these rules apply similarly to other high stakes tests like the MCATs.
So this is Neel. Sorry, I keep losing internet, so my video is off. But yes, absolutely. So these same principles apply across the board. So I've represented students for with the College Board, for the MCAT, for medical licensing exams, like the Step 1, Step 2 exams. And we've represented lactation consultants for their licensure exams. All of these same principles apply. And the DOJ guidance, touches on this, I believe. And the second part of this person's question, just to address that, which is what would you advise doing if accommodations are denied and the exam is imminent within the next few weeks? I have on occasion, requested expedited, consideration of our request. And, again, there's very little leverage that we have in forcing, the testing entities to actually respond on the timeline that we request. But, it can't hurt to ask and to, put that request, I put it in bold that it's expedited, you follow up, you try to make contact with the lawyer for the testing entity or whoever's in charge. Make that personal contact if you can, because I think it's more likely that your requests will get reviewed.
This is Marissa. Any other thoughts on that question? Okay, this is Marissa. So one of the other questions that somebody had was about, how doctors have to fill out all these onerous forms and, they might not be used to the language of the law. How can applicants best prepare and manage reluctant or confused doctors where the hesitancy isn't necessarily because they don't agree with the requested or accommodations, but you know, there's just that level of confusion or not understanding.
This is Erin. I hope this answers your question in a satisfying way, but I think the best way to go about this, because I understand that doctors are often reluctant to deal with any sort of legally adjacent topic, is to bring really clear documentation to them, a really clear explanation of what exactly you need and why you need it. So, I mean, that's one of the reasons we emphasize so strongly the MPRE documentation guidance, because it is really nice bullet points that are in mostly plain English, not legalese, that are easy for a doctor to understand and see, okay, this is what she needs and why she needs it versus, an oral explanation or perhaps something that is a little bit less explicit. So, Neel, do you have anything to add?
Oh yeah, I mean, I think that's great. And a lot of doctors are actually receptive to, you providing bullet points of the substance as well. Um, it depends on your relationship with the doctor, and I would always, of course, frame it as, here are some of the points, that I think would be powerful if they're included in the report, if you see fit. It's always going to be the doctor's decision because it has to be within their, professional opinion. But if you list out bullet points that say, one that sometimes as lawyers, we interface with the doctors or the clinicians and we write, you know, this client not only has ADHD, but has dyslexia and OCD, and that creates, a cumulative impact and creates a negative feedback loop. That's some suggested language that we use because we know the case law recognizes, multiple disabilities, how they can interact and affect someone. Or you can put in that terminology, functional limitations, because we know that that's what these testing entities are going to look for. That's kind of the language of the ADA. And as long as the doctor is receptive, I think a lot of them are appreciative when you give them a little bit more. So, feel it out with that particular situation with the doctor. But most of the time, 9 times out of 10, the doctors have said, thank you for providing this additional information. It helps them do their job, better.
This is Marissa. I'll also say that even if a state bar says, oh, we're denying this because your doctor didn't say reasonable accommodation, right? That is not the law, right? As long as your doctor is requesting specific things based on specific limitations, right? On all the things that they're requesting information on, right? Then they don't have to use some specific magic word under the ADA. Okay. There's a question I see about safety and what if accommodations are needed for safety of exam conditions and not related to performance? How does that intersect with state-created danger doctrine under the 14th Amendment? And when states like California enact state laws prohibiting accommodations necessary for safety, like remote testing, can they be preempted? And I think we saw a lot of that under COVID and continuing with COVID.
That's a really interesting question. And I will, admit that the nuances of the state created danger doctrine are not my area of expertise and are not my ordinary area of law. So when Neel has, of course, lost internet and will rejoin us, but he might have a different perspective. But my perspective on this is that doing the kind of self-advocacy that we've talked about throughout this on sort of the small scale of the personal statement, the explaining exactly what you need and why you need it, the providing the medical documentation, and then the macro scale of working with organizations like the ones hosting this webinar and trying to think about broader advocacy of how we can make the bar exam better and more universally accessible for everyone. I think is going to be part of the solution here. And I'm interested to see if Neel has a different perspective.
Yeah, I mean, I'm not an expert in this by any means, but the only kind of thing that comes to mind is one of our colleagues, Eve Hill, during the pandemic, um, kind of was involved in a landmark case involving the Commonwealth of Virginia, which actually, I believe, banned students from wearing masks. And I wonder if, in having not been involved in that case or studied it closely, I'm just going to put a link in the chat because I wonder if there are some principles from that context, that decision, which might apply to this question here.
This is Marissa. I'll also say that it is still a reasonable accommodation that you need in order to take the exam, right? Like you're not going to perform very well if you simply cannot take it. um, there will be no performance. So I think it kind of comes back to that either way. Um, but there are all kinds of accommodations and all kinds of needs that may be needed in order to take or participate in or succeed on an exam. So that doesn't mean it doesn't apply under the ADA. I see we're at 9:32. I think there are only a couple more questions that I see, but I don't want to keep folks for too long. What do folks think about having these questions written down and maybe we can send out some answers online? How do folks feel about that?
Um, yeah, Marissa, this is Neil. There are two questions that are relatively quick that I might be able to address in just a minute, if that's okay. And then I
Yeah,
think that's a
sure.
great plan. But yeah, typically the letters from friends or spouses, the question was, do those letters of support have to be notarized? And I haven't seen a notary requirement for those letters. The New York bar does require something called a verified petition when you appeal, and that petition actually does have to be notarized. So there are some requirements related to notaries. I see another question about for ADHD, whether you have to disclose taking stimulants like Adderall. The typical guidelines I've seen do mention that if you have taken medication, you should include that information. And I would include it if it's helpful because a lot of times what we can say is, this individual has taken the medication and still it doesn't, totally mitigate the limitations, the disability related limitations. So the student has, taken that step and it just kind of strengthens the need for accommodations, that much more. And one quick other one maybe, which is the private room accommodation. More often than not, I have seen pushback, which was the question, whether there is pushback on a truly private room. I've seen more commonly testing in a smaller environment, a reduced distraction environment with a handful of students. But there are cases where we have gotten a private room. Students, I've represented, a deaf client or hard of hearing client, I should say, whose hearing aids kind of amplify sounds to such a degree that having anyone else in the room was extremely distracting. So that can be provided. And it depends kind of, on each particular case for that, I'd say.
This is Marissa, and if you use dictation of any sort or speak aloud, evidently, you also need to request a private room, and it is not simply always assumed that that is a necessary part of using dictation. So just a little tidbit there. Any other closing thoughts that folks have? I appreciate everybody's questions and, we'll try to answer some of them after this. Okay. This is Marissa. Well, thank you so much to everybody, to Anna, Tenesha, Neel, Erin, and Dulsa as a whole, BGL as a whole, and for all of you for taking time out of your evening to be with us. We will make sure to share this recording, as well as the slides. And I've put some information in the chat about where you can contact us. You can visit Endulsa's website at ndlsa.org, and Endulpa's website at ndlpa.org. And if you have general questions, you can reach out to either of us at info@endulpa.org or info@endulsa.org. And I've also put Neel and Erin's information in the chat, which we can also send out after this. But thank you all so much, and I hope you all have a wonderful evening. And
Thanks
thank
so
you
much,
to the
Erin.
captioners and interpreters.
Thank you. Have a great evening.
Bye all.
Thanks,
Thank
everyone.
you.